Unlawfully.
That is how I recall.
Unlawfully.
That is correct.
So she would
So-
violate her duty of good faith to her employer. She would breach her contract of employment.
I think the contention, Commissioner Kumalo, if I recall correctly, was because the monies are in that environment, she could be approached to make those monies available. I don't know what would be presented to her for her to make those monies available, but that is where the funds are for her to make available.
But if she's doing that as part of her job, how does that rise to gratification and unlawful conduct? Because what you are saying, that would apply to any person who occupies that role.
Correct.
If they are required to provide money, provided that they are complying with the prescripts and they are doing that correctly, that's not a criminal offense.
No, it
They are
isn't.
simply doing their job.
Yes. If she was approached for access of the TSS funds, knowing that whatever that motivation was, she should not approve that funding.
Yes, but how
That
do you leap to the conclusion that she would loot state funds? Because that's what your 25.3 says. If she's approving a request and she's doing it in accordance with the prescripts, there's nothing wrong with that.
Not if she's doing it in accordance with
Yes.
the prescripts.
So what is the basis of your assumption that she would have done it in an unlawful manner?
That she would have been approached to make monies available under circumstances where she would not have made them available.
But how do you know that?
That was because of that environment and because of the fact that from previous matters, not in IDAC, that is how funds were looted. Out of accounts where the funds are within a covert environment. So motivations would be put in for access of that money.
You are being,
Without-
if I may come
so-
in, no. You are being grossly unfair to Mrs. Mukweli. Now you are attributing conduct of persons she has no knowledge of to her in the future know-how. And you are saying you accept that she may be required to access those funds in the course of execution of her job. But the impression you create here at this 25.3 is that she would do so to loot. So that apology that I think you sought to extend to her, you might as well take it back. You are seriously impugning her credibility, and we are trying to find the basis on which you say she was going to loot.
I hear you. That is not the intention. I'm trying to give an example of how I find that space. And,
You see,
sorry, if I...
Oh, no, you may
No,
continue if you're
No,
not done.
I think
Yes.
it is also wholly unfair. There's no intention to impede on her dignity. I am merely expressing or amplifying on the question. If that is how it comes out, Council, really, it is unfortunate that you think that I would, in giving an explanation, that I am intentionally impeding on her reputation and her credibility. I do apologize if that is how it comes out, but, and to say that my apology, in fairness, Commissioners, that I made earlier, I will not willy-nilly make an apology. The Commissioners did not drag an apology out of me. I made that apology freely, and I think it should be taken from where it came. It did come freely.
You see, if there were substance in what you are saying, it would apply across the board. That is to anybody appointed to that position.
Correct.
That must be correct.
Yes.
Yeah, because you have no basis to think that she is different, and that therefore this would apply only to her. So anybody,
In that position.
if what you say is logical, anybody would also be susceptible to this impropriety.
I accept that, Chair.
Thank you.
Advocate Johnson, in June 2025. This is exactly the charge that was presented, even in the draft charge sheet to justify Ms. Mukwele's arrest. It's exactly this. So she has gone through all of this over a period of a year. It's not new that for the first time today you are making this allegation. The memos, the draft charge sheet, and all the documents, this was exactly the issue. And I say this for my part, I have no sympathy for people who loot state funds. And if there are people, whether they are generals or not, who are involved in the looting of the secret account or whatever it is, I have zero sympathy for them. But this case, as Commissioner Baloyi said yesterday, is a serious abuse of power by IDAC to target a civilian. And that's what I have a problem with. My sympathy for her is a bit different to the generals, because if they did what they did, the law must take its course. But we must draw the line where organs that are supposed to protect the public and, you know, work for the benefit of the public are used in this manner to unfairly target civilians. That is just not right.
I understand, hence I made the apology earlier.
Yeah.
It does not detract from the fact that there is a case for which they have now made representations, Memokwele
and
as well.
As you said, it's not just the representations, there's also the review process.
Exactly,
that you referred
and
to.
yes, and so in the end, fairness and justice must prevail. So if we have made the wrong decision, then that decision will be corrected. And I'm saying that in terms of the appointment, I'm not retracting anything that I said at all.
I think my difficulty with you is if you should not think that the fact that there's a review process, there's a representation process, and therefore what you sought to do, which is to prosecute, if those decisions are reversed, then all is good. It cannot be that. Our inquiry is really about why did you make these decisions? It's not about the merits of your case. And I think we may not have fully succeeded to steer from talking to the merits, because they're intertwined with your processes, your thought processes, your decision-making process, what you evaluated, and we compare that with the legislative mandate that you have and requirements. So fact that there will be reviews and representations that maybe do succeed is not really of our concern. Our concern is, how do you make this charge, for example, how does that allegation even arise that she is potentially guilty of a PRECA offense of gratification? But not just her. And she has been the focus of Commissioner Khumalo because she's a civilian. But any criticism that comes out of Section 25.3, in my view, applies to everyone that you have charged with an offense of gratification as defined in PRECA. And it comes from, but there are no facts alleged by Mr. Adams, the aunt, not in his Section 27, not in the affidavit, that paragraph 2 that speaks only about Ms. Mukwele's appointment. Nowhere else does he make allegations that form a reasonable basis for you to prefer a charge of gratification as defined in PRECA. That is really the issue, right? And so the inquiry to you is, why did you authorize that? Why did your investigators get to that point? Why did the prosecutor, firstly your internal prosecutor, get to that point? Why did your DPP, who said, I concur with the charges, they are good, what were they working off? So we're still at first base, before representations and before a review. Where does this all come from, right? And on the face of it, so far, between you and Colonel Pareachi, you haven't given a satisfactory explanation, I must say. And I accept that you're still going to give us documents, the statement, the A1 statements, and maybe we'll see from there what were the facts that led to this allegation in 25.3, but also that led to the charge itself. Absent that, if you do not have documents that show the facts on which this charge or this 25.3 is founded, if you don't have any such documents, then this was an arbitrary decision not based on any facts, and because of it being an arbitrary decision, it is a use of investigative powers for ulterior purposes. If it is not explained satisfactorily for ulterior purposes, then we have to ask the question, what was the purpose? I hope you understand,
understand.
what I'm saying, yeah. So we still have to answer that question.
Correct.
And hopefully your statements will the A1 statements will put us at peace that, well, there was a basis for that. But as matters stand, I must say, from where I'm sitting, that with everything that is before us, and until we get something else, then the exercise of the power to investigate and to charge an offense of gratification under PRECA was exercised without proper consideration, without facts placed properly, and I underline properly, placed before you for this, and the prosecutor and all the people that I've listed, to formulate that charge. On the face of it, the power that you have, all of you that I've listed, you exercise it for an ulterior purpose, and hopefully by the end of the evidence of the IDAC witnesses, we will find out what was the purpose. That, for me, is the real issue here. Do you have anything to say to that? Thank you.